Hello, everyone. In today's video session, I want to talk about some common misconceptions that people have about the VAWA green card. If you are joining me for the first time, my name is Ebony Anoforo. I'm an immigration attorney located in New Jersey, representing clients in all 50 states and around the world with immigration law matters. If you would like to reach me, you can contact our office. Our number is 201-565-0099. But today I want to focus on this particular issue, and that is regarding VAWA misconceptions. So in our office, we do many VAWA cases. It's actually one of our main case types. So we get a lot of questions and we do a lot of consultations where people have misconceptions or myths concerning VAWA. And it affects them, right? Because they're not sure if they qualify. A lot of them don't even know. They just happen to call because they saw a video or a post from either one of our videos, from another attorney or law firm. And they're just calling because they want to see if they qualify. But they had these misconceptions and thought that they probably would not be able to benefit from the VAWA green card process. So I want to talk about some of those misconceptions that have come up that I've seen in the consultations that I've done and working with VAWA clients over the past few years. Number one, let me talk about what is VAWA. VAWA, to qualify for VAWA, the self-petitioner has to show that they are eligible, right? You have to be eligible to apply for this benefit. And this means that they have to show that they have a qualifying relative, and the qualifying relative is their abuser. So this person can be your spouse, this person can be your child, or your parent, right? And you have to show that you suffered at the hands of that family member. And you have to show that that family member had status, and the status has to be either a US citizen or a lawful permanent resident. In order to qualify for VAWA, you also have to show that you've lived with your abuser at some point, right? And I go into more details about VAWA and the process in other videos. Feel free to check them out on my YouTube channel, on my Facebook or Instagram. And you have to show that you, the self-petitioner, are a person of good moral character, right? If you are applying as a VAWA self-petitioner based on marriage to a US citizen or resident, you have to also provide evidence that your marriage was done in good faith, that it was a real bona fide, real genuine marriage. Okay, now I'm gonna jump into some of the misconceptions that we see in our firm. Number one, the most common one is that only women qualify for VAWA. Now, I think people are kind of misled by the name, which stands for Violence Against Women Act. And while it does have women in its title, it's kind of misleading because this immigration benefit was designed to benefit both men and women. In fact, our law firm represents many men who are victims of abuse in their marriages. And we are able to help them with their VAWA self-petitions, help them get a work permit, help them get travel documents and green cards. So I find that many men are kind of suspicious and they're not sure if they can qualify for VAWA. A lot of times they don't even know if what they're going through is considered abuse. So they end up counting themselves out. So that is the first myth that I want to debunk today, is that VAWA is only for women. It's not. Okay. Number two, abuse has to be physical. Okay, this is a really big one. To qualify for VAWA, the petitioner has to have been subjected to a battery or extreme cruelty. And in domestic violence, you can find different types of abuse. It can be physical, it can be verbal, it can be emotional, financial, sexual abuse. And a lot of these forms of domestic violence abuse can amount to extreme cruelty. So just because you don't have evidence of physical abuse, or just because your spouse doesn't physically hit you, doesn't mean that you don't qualify for VAWA. You may in fact qualify based on some other forms of abuse. Number three, that you have to have a police report. Like I just mentioned before, abuse comes in many different forms. It can be physical, emotional, it can be sexual, it can be financial. And for many of those types of abuse, people do not file police reports. People do not report those things to the police. In fact, a police report is great. It's great evidence, but it's not required for VAWA. And many victims of domestic violence never, ever report their abuse to the police. And they do this for many reasons. They could choose not to report because of fear. They don't want to get their family member or loved one in trouble. many different reasons. Maybe they're afraid of their own immigration status, that if they report their abuse to the police, that they themselves will be deported. So you should know from the beginning that a police report is not required. A lot of people assume I don't have a police report, I don't have evidence. That's not true. You do have evidence. One of the most important types of evidence that you have is your own personal statement. And I did a video on that where I talked about how to write a very effective declaration. I invite you to check that out to see some of the tips that I share in that video. Another common misconception is that immigration will contact your abuser. Now, in VAWA, there are several provisions, confidentiality provisions, that make it unlawful for the government to contact your abuser and inform them that you have filed a self-petition. So you don't have to worry about your abuser finding out about it. In fact, there's something that's called a safe address that many attorneys we use. In our firm, we use our office as the safe address, but you can choose the address of a loved one or another family member, where we will have immigration, have the government send all of your documents to. So if you're still living with your abuser, or you have a shared address with your abuser, and you don't want them to know about your petition or that you filed the VAWA green card, you can use another address that they'll never know. It is a confidential process, and you don't have to worry about them finding about it. You don't even have to worry about them being a part of the process. That is why it's called a self-petition. They are not a part of the process. They are not involved. Another misconception is that you must be married to your abuser. This is not true. You don't have to stay married to your abuser. You can divorce, you can become separated, you can leave. You know, there's no provision that requires you to stay married to your abuser. If you did divorce your abuser, you do have to keep in mind that you can apply for VAWA based on this abuse up until 2 years from when that divorce became final. So if you're divorced, keep that time clock in the back of your head, because it has to be done. The petition has to be filed within the 2 years from when it became final. Another misconception that people have that's kind of related is that I have to divorce my spouse. I have to leave my spouse because they abused me. Otherwise, why would they believe me? Why would I apply for VAWA? That is also a misconception. I talk about this a lot because that comes up very often as well. Many people choose to stay married to their abuser. They love them. They continue to have kids with them. However, they're being abused, and they're being abused in many different ways. They're being abused financially, taken advantage of, verbally, right? It might not be physical, but they don't want to leave, right? They don't want to leave because they love their spouse, and maybe they want to work it out. But unfortunately, for whatever reason, their spouse doesn't want to file for their green card. Their spouse doesn't want to help them get their papers and legalize in this country. I've had clients who have had spouses who do love them, but they assert financial control over them, and they refuse to file for their papers because they know that if they get their work permit, they have financial freedom. And that's a way of exerting control. So there are many people who choose to stay married, but they use the VAWA green card as a way to get freedom. They use the VAWA green card as a way to get independence. So that's another myth. You do not have to get divorced. You do not have to separate from your spouse. If you want to get divorced, go ahead. If you are married to your spouse and you are afraid to leave because you think you won't be able to get your green card, so you're staying in a dangerous situation, please consider your safety. Get the help you need. That's one of the first things I ask my clients is, do you feel that your life is in danger? And if you do, you should consider getting the help that you need. Okay. Another misconception that people have about the VAWA green card is that if they report or they file a self-petition that their loved one is going to go to jail. I've actually had most of my clients who have this fear are those individuals who are parents of U.S. citizen children. And they're afraid to apply for this benefit because they don't want to get their child in trouble. They don't want to put their child, you know, as a parent, you don't want to send your child to jail. You don't want somehow this to go in their record, right? So a lot of times they're afraid to file for the VAWA green card because they don't want their spouse or their child in this circumstance to get in trouble. That is a myth. That is not true. Your child is not going to get in trouble because they are mean to you or they are financially cruel to you or they're not going to get in trouble for the abuse that they exert to you. Again, if it's a dangerous situation, you have to do what's best for you and consider your safety. But applying for VAWA is not going to send your child to jail. Another misconception is that you can't apply for VAWA if you have the permanent bar. So VAWA self-petitioners and their beneficiaries are exempt from the permanent bar. If you feel that you have the permanent bar, and you want to apply for VAWA, I encourage you to speak with an immigration attorney to talk about your options, possible waivers, and so forth. But yes, this is another common misconception that we hear. If for whatever reason you have questions on any of the misconceptions that I discussed today, you believe that you qualify for VAWA, or maybe someone you know qualifies for VAWA, you can go ahead and give my office a call. Our number is 201-565-0099. You can schedule a VAWA case evaluation. We are happy to help you. We help clients every day. We are dedicated to helping victims of abuse and domestic violence get a green card on their own, self-petition, and work towards their way to freedom. We love to help these clients. It is our mission in this firm to help as many clients as we can get legal status in this country, especially those who qualify and who may not have the means or the tools to be able to get those things for themselves. So if you have any questions, if you know anyone who might benefit from this information and want to speak to an attorney, you can go ahead and contact our office. Again, we are 201-565-0099. We're located in New Jersey, but we represent clients all over the world, all 50 states with immigration law matters. Thank you so much again for tuning in, and I will see you in the next video. Take care.